Hi, and a very good evening, everyone. Welcome to EBC Learning. I'm Dr. Rachel Dua, and I take care of the operations and delivery of the courses at EBC. Great to have you all here today for another interesting live session of EBC's podcast on trademarks. We will be discussing the fundamentals of choosing a trademark and will also understand the complexities of trademark. We have with us today Mr. Rajesh Ramanathan, partner at Spectrum Law. Welcome, Rajesh, to EBC Law.
Thank you.
Introduce you now. Rajesh is an advocate with over 28 years of experience in national and international commercial dispute resolution. His areas of expertise are IP and related services, including prosecution and transaction contentious and non-contentious litigation. Earlier, Rajesh headed the IP law practice of a reputed national firm. He has also been in charge of the Southern India operations of a leading IP firm as its senior associate. Rajesh has a vast experience in litigation, prosecution, anti-piracy operations, and transactional services. Rajesh is an alumni of the Franklin Center for Intellectual Property at the University of New Hampshire Law School, Concord, New Hampshire. So we at ABC are delighted to introduce Rajesh as one of our premier authors and an exceptional speaker. In addition to his contributions, Rajesh has developed comprehensively a course on traditional knowledge with us. Welcome again, Rajesh, to EBC Learning, and it's always a delight to have you with us as a speaker, as an instructor. Over to you now, Rajesh. We want to have your session now. Thank you so much. Thanks. Please take it forward from you.
Thank you, Anshul. That is very kind of you. Always a pleasure to be part of EBC Learning. See, the topic we discussed today are unique to me. It's trademarks. To me, is one of my favorite subject. I'm passionate about it. And if you look at the title, the topic, branding conundrum. Why should there be a conundrum in branding, right, and a trademarks? Where does it conundrum arise? The conundrum arises when there is a difference of opinion between the legal team and the marketing team. Right? In this session, we'll cover why that conundrum arises, what are the fundamentals of trademark law, fundamentals that you should consider while choosing a brand, and then what happens once you choose a brand and how do you enforce it as a registered proprietor. So I'm trying to cover two different aspects of trademark law today. One, the fundamentals of what a trademark is. What should you consider both from the perspective of a law student, a lawyer, and a brand owner? And two, how do you enforce once you chose? So it's a very interesting perspective being covered from both angles. Let us start by looking at what happens when there are no proper consideration in choosing a brand. What happens when only the marketing team, without a consultation of legal team, many cases, I'm not saying all cases, predominantly in many cases where you don't consult the legal department and just go ahead and get a brand name for your whatever business that you are in. More often than not, it ends up in litigation. We'll see why. We'll see some examples of some brands and the consequence of being very famous. Look at the logo of these two, Energy Armor and Electronic Arts, a direct bad infringement. Star Sports and Malta Star. See how Think Free designs its logo. Think Free offers was Google Chrome, and now Starbucks and Star Prayer, Buckstar. See how closely they are trying to match with the famous brands. Dolce and Banana and Google used for napkins or paper towels. Probably many of these are from Chinese, I don't know. So, but what does this tell you? This tells us that choosing a brand is not always a simple job. Choosing a brand requires a lot of thought process, both at the marketing department and more importantly, the legal department as well. So why does it require that? The law which deals with all this branding is the law of trademarks. Currently, the Trademarks Act of 1999 governs the area of trademarks in India. What is a trademark? A trademark is a source indicator, a source identifier. Now, to give you an example, the moment you hear the word Coke, you automatically, the previous slide, let's stay the previous, yeah. We automatically identify it with the source of the company, Coca-Cola company, right? The moment you hear Pepsi, you automatically go to PepsiCo, or the word Apple, you identify it with the products made by the Apple company. So a trademark is an indicator of origin. It's a liaison between the product and the author of the product. What can be a trademark? What all can be a trademark is, I've tried to give you some examples. A name, a logo, which is also called a device, a letter, a signature. The next slide, please. Just the numbers or the packaging, the shape, that is the shape of a Coca-Cola bottle. It's very famous. The color, the purple color of Cadbury, it's part of a lot of litigations in India and abroad as well. Or any combinations thereof. So, stick to the previous slide, please. So, as far as choosing what to choose as a brand, anything can be a trademark. The definition says, under the Trademarks Act, it defines any mark. All these are marks. Whatever the list you saw are marks. Any of these marks which are capable of distinguishing one's goods from those of the others. So the essential feature is to distinguish one's product from those of the others. As long as this is covered, anything under the sun can be a trademark. Now we'll also look at, these are all traditional trademarks. We'll also look at non-traditional trademarks in a while. But what are the categories of trademarks we have? These are the lists. Anything under the sun can be a trademark. What can be registered as a trademark? What the law says is a trademark has to be distinctive. For it to be recognized and registered to an applicant. The distinctiveness can be of two kinds. Inherent distinctiveness and acquired distinctiveness. We're going to look at what the Trademarks Act 1999 speaks about the categories, but these are the two basic categories that you all have to remember. Inherent distinctiveness, acquired distinctiveness. Next slide, please. Section 9 of the Trademarks Act speaks about three categories: distinctive, descriptive, and generic. Distinctive, I told you there are inherent distinctiveness. 918 talks about inherent distinctiveness, which are further categorized into two: fanciful and arbitrary. The next slide, please. Fanciful, in other words, coined, which has no meaning. Xerox, Kodak, Yahoo, Google. They have no meaning. It's just fanciful. They came up with, suddenly it dawned on them to come and keep this name. Right? It has no meaning. Arbitrary has a meaning, but is applied to an article which is not connected to that meaning. I've given you examples. Apple for computers, Amazon for virtual marketplace. So these two are part of the inherent distinctive category, which has a maximum value as far as the trademark law is concerned. It has a maximum value and it is inherently registrable. The next category, next slide please, descriptive. This goes into the second class, second category I told you about, acquired distinctiveness. Descriptiveness is further categorized into suggestive and descriptive. Suggestive, for example, aqua. You know that aqua has got something to do with water. Can be anything. Can be a water treatment plant, can be a drinking water bottle manufacturing plant, Jaguar for cars, just to denote speed. It suggests. And descriptive, it's directly descriptive, like hot chips for chips, hot breads for breads, vision care for optical stores. These can be registered once they are able to establish that they have, by way of use, they have acquired a secondary meaning amongst the consuming public. So this will fall under the category of acquired distinctiveness. 9(1)A talks about distinctive mark, which is inherently distinctive. 9(1)B talks about descriptive, which can become registrable once it acquires distinctiveness. These are the two categories of marks which can be registered. The last category is generic. The next slide, please. Generic is common to the trade and cannot be registered. Right? It is available for the entire world to use. No one person can claim any monopolistic right over that particular name or whatever the list is. Hot breads, kerosene, videotape, when it originally came into being, it was launched as a trademark. We'll also talk about some trademarks which are very famous, but acquired the status of a generic trademarks because of its use. Why? Remember, in the beginning I told you, the role of a trademark is to identify the source. As long as a trademark identifies a source, it remains as a trademark. Instead of identifying with the source, if it starts identifying itself with the very product or the service, it becomes common to the trade. It becomes generic. We'll see quite a few examples. I can give it to you, but anyway, it comes in the latest slide, but I'll tell you right away. Cellophane tapes. Cellophane tapes, whenever it was launched, it was a trademark. Escalators. Escalators was a brand name when it came out. As long as they were identifying with the source, that is the company, it remained as a trademark. Because it became so notoriously famous, people started identifying it with the very product itself. So cellophane tapes became the product. Escalators became the product. Britannia, the Marie biscuits, tea biscuits. Britannia had originally had it as a trademark. The Marie biscuits became generic. Aspirin tablets. So all this were once very famous trademarks, and the moment they stopped identifying with the source and started identifying with the product, it lost its trademark value and it became generic. So when you choose a brand name, it is very important. I'll give you a fantastic example. Xerox. Right? How many of us use a term photocopying now? Nobody uses. Get me a Xerox copy. Right? But now please go and check the promotions of Xerox company. They will say Xerox, the photocopy machine. Xerox, the photocopy company. They will try to distinguish between the mark and the activity so that they can identify the mark with the source, the Xerox company. Doing that, Xerox was able to retain its trademark value in many of the countries. In few countries, in few jurisdictions, they have lost their value. In fact, in India, they've lost for a few products. They were able to retain it for a few other products. And I was part of one of the litigation, part of that was a decade ago, where in the Madras High Court, there was a photocopy store. They called it some Xerox shop. So they were sued. They did not expect, Xerox did not expect this man to revert. He fought. He challenged the registration before the Intellectual Property Appellate Board, went on for a long before the registry, then before the Intellectual Property Appellate Board, went on for a long time, and finally, I think Justice Prabhas Sridevan held it in some classes, I think in class 16 and some other classes for stationery and all those things, it was held in favor of Xerox. In one or two classes, it was held to be generic. So they lost it and then they regained it. The best example of how to brand yourself. It is very, I cannot stress the importance of this liaison between the product and the author of the product. As long as there is a liaison between the product and the author of the product, that is the role of a trademark. To liaise between the product and the author of the product. When this liaison disappears, the trademark value disappears. So please keep this in mind. Next slide, please. We spoke about descriptive marks. A descriptive trademark is generally not protectable unless it acquires a secondary meaning and therefore acquired distinctiveness. Next slide, please. A distinctive mark, a coined or fancy word or arbitrary mark, it is simple and easy, straightforward to register. Protection is straightforward and has a maximum value as far as trademarks are concerned. Generics can never be registered. I told you about escalators, cellophane, aspirin, and tea biscuits. So what then is the fight? The eternal fight is between the distinctive and descriptive trademarks. So the marketing team wants to choose a name which will be more attractive to the consumers. But the legal team would want somebody to choose a mark which is easy to protect. Two different spectrum. Right? So what is the best method? Balancing these two is the best method. You need a distinctive trademark, but at least you have to work with the marketing team to come up with a suggestive mark so that they can acquire distinctiveness in no time. Next slide, please. I will tell you what are the do not do's when choosing a trademark. Don't misspell a famous mark like Wipro. Don't use a name, even though it is allowed under the act to use your own name. But if you're going to use your own name to come as close as possible to a famous brand, you will be restrained. No scandalous or obscene marks. Don't use government emblems because it is always a problem. I'll give you one of my experiences. It's, I think, a decade ago. For people who are either from Karnataka or know, the history of Karnataka, there is a very famous mythological creature called Gandaberunda. It's an eagle with a twin-headed eagle. This mythical creature relates back to the story of Lord Narsimha, one of the Vishnu avatars. This twin-headed eagle is also the emblem of the Mysore Maharajas. Two traditional royal jewelers started using a different form of this Gandaberunda, and they started fighting with each other. So the Mysore, the palace, and also the state, the Gandaberunda became this emblem of the state road transport also. So it was a three-corner fight that we have to face. I was appearing for one of the jewelers. Eventually, we were able to establish that the mythical creature that is found in the emblem is different from, or the form was different from what we are using, and therefore we have the right. And we also made sure that the litigation between the two royal jewelers kind of eventually settled. But these are the problems you will face if you're going to choose, because choosing these emblems, which is very popular amongst the public, so that you can easily attract consumers towards you. But say, if you keep using it, initially nobody would bother, where everybody will come to you. But what happens after a decade or two, once you use it and suddenly somebody comes and says, sorry, that is not your emblem. It is a government emblem or something which is protected by the Emblems Act. You will eventually end up losing your brand. Next slide, please. Don't use celebrities' name. Don't use symbols of the monuments or any geographical names, because it is always a problematic. Next slide, please. If you want to use a descriptive trademark, like I said, suggestive or descriptive, don't go for registration immediately. Use the mark as widely and extensively as possible. Create a reputation for that. Advertise, do all the promotional things so that the consumers are able to identify that descriptive mark only with the source. Like for example, crystal for salt. And then the moment you realize that it has acquired enough distinctiveness, and don't go for registering the word per se, apply for the entire, including, say, for example, come up with a unique, distinctive logo or a distinctive script. The general principle should be, higher the descriptiveness, the more distinctive the logo should be. I'll give you an example. Next slide, please. Vision Cat, if you look at it, is very descriptive for spectacles, anything eye care. Choose a script which is unique. Choose a logo which is descriptive. See what they have done. The next slide. Vision Care R&D, and look at the logo. The way Vision Care is right, they may not get an exclusive right over the word vision or care, but they will get an exclusive right over the way it is reproduced. The way the logo is there. Very difficult. This becomes distinctive. This acquires distinctiveness in no time. So if at all you have to choose descriptive mark, please, you have to follow all these things. But if it is distinctive, please, please, please apply for the word per se, so that we can get the widest possible protection. And please remember, registration of a trademark is for the goods or services which are used or you are proposing to be used. When I have had clients coming to me and said, sir, I'm going to use it only for this particular product, but I want you to apply for all these products because in future I might use it. That opens up a Pandora's box. So apply for goods or services which you are using it, or you actually propose to use it. And what happens once the choice is made? Next slide, please. Once the choice is made, conduct a search, because this helps you protect against a lot of litigation later. And you can also come up with an idea of creating this valuable trademark, creating an asset. All these times we spoke about traditional trademarks, and now I told you there is also a non-traditional marks, which are sound marks, smell, color, shape. In fact, Cadbury is fiercely protecting its purple color, which is registrable. Britannia, so I'm sure you all remember the moment you read this, automatically the sound will go in your mind. Ting, 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 ting. I have a very interesting story when it comes to sound marks in US, because I did my master's in US. When I was there, Harley Davidson applied for its sound of an engine as a trademark. I don't know how many of you are familiar with the Harley Davidson's sound. It's more or less similar to our Royal Enfield bullets here. My trademark professor would call it a potato sound. Keep repeating potato fast. Potato, 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 potato. That is the sound of a Harley Davidson. I remember seeing an ad on HBO, the television, those times. The scene is like this. An empty road in a busy street in New York. A blind African-American, blind elderly African-American trying to cross the road. He will cross the road, halfway through he will stop. He will hear a sound. Then he will say, Harley. Just by listening to the sound, he'll be able to identify. So the basic function of a trademark, they're trying to promote that function, identifying with the source. It's a beautiful way of promoting your sound, saying that this sound is mine. This sound is Harley Davidson's. They applied for a trademark. For some reason, best known to them, they withdrew it later. I don't think there is any, they followed it up with that. But in India, I think Chanel has applied for a trademark, smell trademark. So anything under the sun can be a trademark. These are non-traditional trademarks. The only problem in applying and getting it registered is you will have to graphically represent this before a trademark registration. Sound, how will you graphically represent a smell? You will have to describe it. How will you graphically represent a sound? Of course, you will be providing a CD and everything, but you'll have to graphically describe it. That is where a lot of, because the law is still traditional, they have not changed that. We are still figuring it out. But that is the law. And as long as you're able to graphically represent the trademark, and as long as the trademark is identifiable with your source, you have a distinctive trademark. And it's always better to go with a distinctive trademark. So what are the advantages? Next slide, please. I've listed out few of the advantages of getting it registered. Protecting a brand. It enhances the value. It shows that the brand owner is really vigilant. It also shows the growth and success of the brand. And it is also better protection and enforcement will result in better investments for future. Next slide, please. And brand management is a very, there are people who are doing just this without anything else. A better brand management result in longevity of the brand. And eventually, whatever you spend for the brand will come back to you as profits. Look at the brand values of all the leading brands. Every year it changes. Every year the rank changes. Look at the millions of dollars that just the brand value gets them. Right? So as far as choosing a brand is concerned, please remember, it is the distinctive trademark which will give you the value. And if it is descriptive, use it so extensively before you apply for it so that it acquires distinctiveness and then register it. And therefore, you create a value just for the asset. This is as far as the conundrum is concerned. Once you register it, how do you protect it? Now, the next part of the presentation moves to enforcement. Next slide, please. Next one. For all these law students and lawyers, section 27 to 27, 28, 29 talks about the rights of a brand owner. 30 to 35 talks about exemption. So you will have to go through section 27, 28, 29 for the rights, 30 to 35 for the exemptions. Let's just talk about some. Section 27 gives a right. See, only a registered proprietor can take shelter under the law and seek relief of infringement of a trademark. What happens to an unregistered trademark? And there are many trademarks which are not registered, but which are very popular, which have been there from a very long time. There is something called as common law of passing out. 27.2 gives a right for a person, for an unregistered trademark owner, to sue for passing off against any infringer. Right? So it is not necessary that you must register your trademark. Registering a trademark is recommended, but if you have not, you still can protect your trademark under the common law of passing off. 20, I'm not going through 28 when all the provisions, just giving you some essential, interesting ones. Section 134 gives you where you can file a suit for infringement. When I say suit, it's a civil action. A suit for protection of a trademark has to be filed in any court not less than a district court. So it is only the district court. In a district court, you can ask for the infringement of a registered trademark, any right in a registered trademark. C, for an unregistered trademark, you ask for passing off. An injunction restraining the defendant from passing off their goods as and for that of yours. And it has to be instituted in any court not less than a district court. You might have a question. For all the lawyers, you will find that the high courts having original jurisdiction also try these suits, right? Or commercial division in the high court. Now 134, all these become part of the Commercial Courts Act, and you have to go to the commercial court. High courts having original jurisdiction, as far as the CPC is concerned, are nothing but a district court for the city where it is. For example, the original jurisdiction of Madras High Court extends its jurisdiction over the city of Chennai. Same with Bombay, same with Delhi, same with Calcutta, and same with Allahabad. These are the courts which has original jurisdiction, of which Mumbai, Bombay High Court, Madras High Court, and Calcutta High Court are original courts chartered by the British. So it has been there for almost 150 plus years. So these courts, you can file a suit directly in the High Court in the original jurisdiction. Next slide, please. What are the reliefs you can claim? Obviously, a permanent injunction against your registered trademark for passing off, damages or accounts of profits, and delivery up of the labels, whatever is with the defendant, for them to be destroyed. Please remember, both infringement and passing off are maintainable only in district courts, not in any other court. So the relief you can claim, next slide please. The relief you can claim, injunction, damages, delivery up of goods. A general principle of law as far as passing off is concerned. This is what is being there. Please look at this. This was observed in 1842. A man is not to sell his own goods under the present pretense that they are the goods of another man. He cannot be permitted to practice such a deception. He cannot be allowed to use names, etc., by which he may induce purchasers to believe that the goods which he is selling are manufactured of another person's. I have no doubt that he has no right to use the mark. This is the principle which is still held good as far as passing offs are concerned. So this is, when it comes to passing off, what is the difference between infringement and passing off? That will come in the next slide. Next slide. In a passing off action, the previous one. In a passing off action, the next one. So in a passing off action, the main question is the defendant selling his goods such as to market or calculate to confuse the purchasers to think that they're the plaintiff's goods? In a passing off action, the focus is on the goods. But in an infringement action, the question is the defendant using a trademark identical or similar to that of the plaintiff? Right? Passing off deals with the products or the services. Infringement of a registered trademark deals with the mark itself. Monstrous injustice would have been done if a man who has had a trademark for perhaps 40 years, in the previous slide, should lose it because another man who has had it for 4 years had happened to register it first. Very important fundamental principle of passing off is that action can lie even against a registered proprietor of a trademark. That is why I said registration of a trademark is not mandatory. You can protect a trademark under the common law of passing off as long as you establish that you are a prior user. So passing off action, even against a registered proprietor, is available. When it comes to passing off, courts will look at the classic Trinity test, the goodwill of the plaintiff's products, the misrepresentation done by the defendant, and because of the misrepresentation, the damage it has done to the goodwill of the plaintiff. This will be the classic test, we call it the Trinity test, which the court will have to consider whenever there's an action for passing off. This particular case that in Delhi, one of the classic cases on passing off, if you get an opportunity, please go through that and read, because it also discusses several judgments, both foreign and Indian. BK Engineering, they are the manufacturers of cycle belts. Their house mark is BK, which is engraved on the bell. The defendant started using the mark BK81. The defendant tried to take defense saying, BK is my mother's name. Some Bharat Kaur or some Kaur, I don't remember the name, full name exactly. And therefore, trying to take shelter under Section 35, use of one's own name. But the court held again, granted an injunction in favor of the plaintiff and said, sorry, you will not fall under 35 because it is not your name. 35 does not give you a right to use anybody in the family's name, my wife's name, my mother's name, my father's name. It has to be your name to claim the defense under Section 35. So idea behind the case is to avoid confusion due to similarity, irrespective of using one's own name or anything. So there is also another important famous case of Bajaj, where somebody said, my name is also Bajaj, I'm also trying to use it. So the court said, sorry, your name might be Bajaj, but here the idea is only to create confusion in the market, and therefore we're not giving you. So that consideration, the courts will basically apply this Trinity test. The next slide, please. Prior user. Like I said, prior user is superior even to registration. When all these judgments that I've listed out, the classic, very interesting to read, when each and every judgment we can discuss for a good 20 to 30 minutes. They have discussed so widely, so many judgments covered, so many discussions happened by both Bombay, Delhi, and Madras. But obviously, we only have an hour and a half, so we won't be able to go through everything. In the consolidated foods case, the previous one, the court held you don't need to use it for a long time to acquire reputation. Reputation can be achieved irrespective of the length of the use. A single actual use with intent to continue such use confers a right. That is it's a boon. This judgment was a boon to all the brand owners. You don't have to use it for a long number of years to say that I have a right, I have a reputation. Even a single use, as long as it has the capacity to attract, to reach so many consumers is enough, is what the court has said. Prior user, this is the first time that the court has to deal with a prior user in the world market with a prior user in India. There are many cases. If you look at all the major brands in the world, initially they didn't want to enter India because of obviously the red tapeism here or whatever the reason might be. But that gave an opportunity for all the local manufacturers to start using their names. The first time where with Allergan was a millman, the trademark in dispute was Ocuflux. The court said they are the first in the world, and therefore the court was able to apply the transborder reputation, transnational reputation to hold it in favor of the plaintiff. The next case that is listed here, that is Manikchand versus Manikchand. The plaintiff filed a suit for passing out. The defendant Manikchand said, see, I'm a bigger player. Manikchand is a small player. You should actually consider my reputation, now that I have a better reputation. But sorry, it is the first in use that is important, the prior user that is important in passing out, and not the bigger user. So it doesn't matter how big you are. It matters when you have commenced use. So use, when it comes to trademark cases and enforcement, use becomes very, very important. Then you have overall similarity. This is also a very interesting case. If you get an opportunity, please go through this judgment. Here, it is of Madras High Court. The court will list out 36 differences in the two packagings of both iTex and iWix. But still the court says we only have to look at the overall similarity and held it in favor of the plaintiff. When it comes to trademarks, if you are interested in practicing law of trademarks, you will come across a plethora of opportunities to work in pharmaceutical cases. It's either pharmaceutical or FMCG. And the most important when it comes to passing off in pharmaceutical cases, Supreme Court's judgment in 2001 in Cadila Healthcare was Cadila Pharmaceuticals. Please see the one. Drugs are poisons, not speeds. Confusion between medicinal products may therefore be life-threatening and not merely inconvenient. Noting the frailty of human nature and the pressures placed by society on doctors, there should be as many clear indicators as possible to distinguish two medicinal products from each other. This is a case. The trademarks in dispute was Falsitab and Falsigo. Please read, if you had an opportunity, please go through this. It will take you an hour or two to read the entire judgment because they would have gone through a plethora of cases again to discuss passing off. This is also a classic case where the Supreme Court says it is the similarities rather than the dissimilarities that should be considered to determine whether there is a likelihood of confusion or not. And Supreme Court gave a list of considerations for every court to consider passing off. These are the factors to be considered to decide whether there is a passing off or not. A, the court has to consider the nature of the marks, whether it is a word mark, a label mark, device mark, a composite mark. The degree of resemblance, either it is phonetically similar or the device is similar, identical, what is the degree of resemblance? The nature of the goods in respect of which they are used, the similarity in nature, character, and performance. And who are the purchasers? Who are the consumers? Are they educated, illiterate? What are the intelligence level of those purchasers? The mode of purchasing, and it assumes significance now that the shopping happens virtually. And any other surrounding circumstances which may be relevant to the extent of dissimilarity between the competing mark, and weightage to be given to each of the above factors, not the overall. So this is the yardstick. Now the court has started applying since 2001 after this case. And a very interesting saga when it comes to Liv 52, a dispute between Liv 52 and Liv T. Initially, the single judge of Delhi High Court grants an injunction, which is confirmed on merits. Division bench says, sorry, Liv is an acronym of liver. And so it is common to everyone, everybody can use it. Goes back to trial. The trial judge then dismisses the suit saying Liv is common to trade. Comes back to division bench. Division bench finally said, Liv 52, Liv 2 ought to be looked at as a whole, and the defendant, as long as he uses Liv with some suffix, he's entitled to use it. So if you are able to read all the 3 or 4 judgments that you can get your hands on, the entire gamut of trademark law and passing off law is so beautifully discussed in these things. After the pharmaceutical cases, we'll now look at, when it comes to infringement, there are 3 things. Section 29 talks about 3 things. Please remember this. When it comes to infringement of a registered trademark, the 3 categories are: 1, where the trademarks are identical or similar. Now, where trademarks are identical, goods are similar. There will be cases where goods are identical, trademarks are not identical, trademarks are similar. There will be cases where both the goods and the trademark are identical. 29(1)(c) says, when both the goods and the trademark are identical, likelihood of confusion is presumed. So there is no need to establish anything. But when it is not so, when one is similar and the other is different, identical, then the principle that we look at now will have to be considered. Now, what happens when the goods are different? Trademark is similar, are identical, but the goods are completely different. You will have a plethora of judgments from all over the world on these things, which we'll look at now. It becomes assumes a lot of significance when it comes to trademark law. Please look at the judgment, the case that I have listed out, which is of the year 1910. The dispute was between Scissors, the cigarettes, and Scissors, the defendant was manufacturing BDs. Of course, plaintiff had a right to it was held in favor of the plaintiff. But what the court also held is we have to consider the sale of the Scissors brand of cigarettes depends a great deal upon the reputation of the brand and is likely to decline if that reputation is in any way affected. And it seems to me that the plaintiffs are justified in being apprehensive that if those BDs are widely sold under the Scissors brand and are consequences believed to be the manufacturer of the plaintiffs, that might affect the reputation of the plaintiff. So basically, it is the court focused on the reputation of the Scissors cigarette brand, plaintiff's brand, which later, under the 1999 Act, led to the legislation of Section 29(4). 29(4) is the one which talks about what happens when the goods are different. Trademark is similar or identical, but the goods are different. The important essential ingredients, I have not listed out the provision here because it's going to take a long time. 29(4) talks about the law of dilution, where a plaintiff's trademark has a reputation in India, has achieved a reputation in India. The goods are different, and the defendant, with using the trademark without any due cause. These are three essential ingredients of law of dilution. Plaintiff's mark has a reputation. Defendant is using it in different goods, using it without any due cause. If we're able to establish that, then defendant's use is likely to dilute the reputation of the plaintiff, and injunction would be granted. Let's look at the next slide. 1935. In this case, elephant cigarettes is elephant chewing tobacco. Here the court held otherwise. It is not impossible for some ignorant and particularly indiscriminating persons to mistake the defendant's goods for those of the plaintiffs. But persons exercising ordinary caution are not likely to assume that the tobacco sold by the defendant was manufactured by the plaintiff. So the court took a contrary view here. So it differs from one case to the other. Please go to the next one. Next slide. 2000, United Distilleries was Jagdish Joshi. Somebody was using Johnny Walker for Gudga, also using the color combination. Court held it in the plaintiff's favor. Right? So, when the goods are different, unless and until the plaintiff's mark is established to have a reputation in India, you won't be able to stop the defendant. Now let's go to the next sector, which is on trade dress. Very interesting case in 2009. This is for the 555. I'm sorry, I have a lot of cigarette examples and alcohol, both of which I don't take, but you have a lot of cases on that. 555's trade dress is of cream color cotton with numerals 555 written in dark blue background. Defendant uses this, but uses a different trademark called Peacock. So the trade dress was identical, trademark was different. Court held it in favor of the plaintiff. And a very interesting aspect of infringement of trademarks when it comes to trademark is under section 29(5). Next slide, please. This I would like to read. A registered trademark is infringed by a person if he uses such registered trademark as his trade name or part of his trade name or name of his business concern or part of the name of his business concern, dealing in goods or services in respect of which the trademark is registered. 1999 law came up with this to protect a registered trademark from being used by defendants as a trade name. Right? There is a difference between 29(4) and 29(5). The defendant may not use the registered plaintiff's trademark as a trademark, but can use it as a trade name, as a company name. And this law was trying to protect it. But two essential ingredients. the defendant has to use the entirety of the trademark as registered, and it should be for the goods identical to which the trademark is registered. Only if these two conditions are satisfied, court will restrain the defendant from using the trademark as a trade name or part of a trade name. I had an experience in Chennai a few years ago, 5-6 years ago. I don't know how many of you are familiar with this brand called Tirumala Milk. I appeared for the defendant. The defendant used Tirumalai Vasa, both representing or both claiming to be devotees of Lord Venkateshwara. Tirumala is Tirupati. Tirumalai Vasa is the deity of Tirumala, which is Lord Venkateshwara. So the court held, I lost the case initially, that as a trade name, the defendant is using the entirety of the trademark Tirumala in Tirumalai Vasa. And therefore, the court threatened an injunction, but eventually the matter got settled. You'll have plenty of opportunities where a defendant would like to use a registered trademark as either a trade name or part of a trade name. And you have to use only section 29(5). You can't go on to any other provisions of law. 1980, plaintiff was selling clocks under the trademark Ellora. The defendant started using Ellora as a trade name or business name for selling timepieces under a different trademark. The court said, the Adelaide court said, this is nothing but an extension of passing out and expanding business talk. So basic principle of common field of activity and probability of damage was used to hold it in favor of the plaintiff. The next slide, please. It's a very interesting case between Raymond, the clothing, and the Raymond Pharmaceuticals. Here the court held in favor of the defendant. This also discusses the aspect of section 29(5). The defendant succeeded here because they were dealing in a completely different goods in respect of which the trademark is registered. So section 29(5) will not, the court said it will not come to help the plaintiff. So you'll have to look at both section 29(5) and 29(4) as mutually exclusive. The well-known status of a mark does not entitle automatic protection at 29(5). 29(4) talks about law of dilution. 29(5) talks about use by the defendant as a trade name or a business name. Next one, please. There's again a very interesting dispute between Mankind and Mercykind. Use of a trade name similar to the registered mark would not constitute infringement of section 29(5). 29(5) is very clear. The registered mark as a whole should be used by the defendant in his trade name, and it should be in identical goods as the plaintiff has registered his trademark. Here, Mankind and Mercykind were held to be different because the trade name used was not the same as the registered trademark. This is as far as 29(5) is concerned. Now, I've just added some tidbits to you. As far as you will come across a lot of domain name disputes. We need a separate session for all these domain name disputes. Now, I'm just giving you some examples of these disputes. But apart from the code, you can also approach ICANN and .in registry. They provide arbitration for a retrieval of the domain names. But if you want a restraining order, if you want damages, you will have to approach the court. Just continuing with the, these are the very interesting case on domain name. It's most of the, if you are able to go through this judgment of Arun Jaitley's Network Solutions, it also deals a little bit of personality rights, punitive damages against trafficking and all. Very interesting. But it is a simple infringement of trademark, but a separate category, interesting to read. Let's go to the other aspect of infringement. One of my favorite are two other aspects. Adverts, and then we'll also see disparaging advertisements. And for adverts, one of the parties, the defendant most of the time will always be Google. Because adverts are part of the advertisement program of Google. There are search strings that rival business can bid for placement of ads. So, for example, Bharat Matrimony. Bharat Matrimony and Google is something which is going on in Madras High Court for a very long time. One after the other, something else is happening. Google has placed adverts for Bharat and Matrimony in several different parties. So whenever you type Bharat Matrimony or Tamil Matrimony or Telugu Matrimony, the bharatmatrimony.com will not come up. Some third party's name would come up in their adverts. Next slide, please. Please look at the judgment in division bench of the Madras High Court. Injunction was refused, confirmed by the division bench of the Madras High Court, stating Tamil Matrimony, Telugu Matrimony, etc. cannot be prevented from being used as a descriptive expressions and adverts by competitors. Actually, Google succeeded and Matrimony lost. The division bench in this case also held that the consumer is very knowledgeable and tech savvy, and he knows what he wants and what he is doing, and he's not going to go after what the adverts say. And the next sector thing on infringement is comparative advertisement. Next slide, please. I want to inform you that EBC has published a book on comparative advertisement last month. And I'm very proud to say that my senior, Chandar M. Lal, an authority on this law, has authored that book, and he has worked on it for almost 15 years. And one of the best, probably the only book that is available on this area of law in India. And if you can, I'm still reading it. It has a lot of case studies with the ads, with the pictures of the ads. And it's a good 200, 300 pages of book exclusively on this area of law, which is very interesting. And I was part of the launch last month in Delhi High Court, and where Supreme Court judges and Delhi High Court judges were there, and they're discussing this area of law. I wish some of you were there. Pepsi and Hindustan. Pepsi and Coke always get into a fight on comparative advertisement. So the basic principle is that the usage should be in relation to the goods of the appellant, and in such a manner rendering the use of the mark likely to be taken as being used as the trademark by the respondent. But when it comparative advertisement, puffery is allowed. Puffing one's product by comparing others' goods and saying my good is better is not an actionable claim. But when puffering or poking fun leads to denigration of a competitor, that becomes actionable. Puffery is allowed. I am good. I am better than you is okay. You are bad is not okay. That is the difference when it comes to comparative advertising. Next slide, please. Then you will find a lot of fight between Horlicks and Complan. Here, repeated use of the word cheap and compromise along with the remaining insinuations would definitely harm the reputation of rival brand. And therefore, it was held in favor of the plaintiff. And court held that television visual advertisements make an instant impact on the consumers. And therefore, the level and extent of impact is much greater than a print. And therefore, the advertisement have to be much more careful when it is more visual. And next slide, please. And currently, the hot topic as far as comparative advertisement is between two companies. Glaxo and, the next one. Reckitt Beckinsale and Hindustan, the previous one. The previous one, no, you're.
Sorry, I think I missed it somewhere.
Yeah, it's okay.
Should I go further?
Previous one.
Okay.
Previous. This was stop. This is a case where court held a 3-step process to determine if the plaintiff's claim can succeed. This is between Dettol and Lifebuoy. during the COVID-19, it was an advertisement by Dettol, and it was denigrating Lifebuoy during COVID-19 pandemic. The court said it must be misleading and a false claim regarding a product. It must deceive the consumer, and that deception should affect the consumer behavior. So the plaintiff, it's a tough task to prove before a court that it is misleading, that deception, that must lead to a deception of the consumer, and it should affect the behavior. Only if 1, 2, and 3 are complied with, then the plaintiff can succeed in his claim. This is as far as the different aspects of civil release. There are also questions raised as whether any criminal action is possible. Chapter 12 of the Trademarks Act deals with criminal action. Section 101 to 121 deal with aspects. But the only thing that is always I advise against clients against taking the criminal route, because for a criminal action to succeed, Section 115 mandates that an officer of a DSP level has to obtain an opinion before the registrar of trademark. Unfortunately, by the time you obtain the opinion and get ready for action, the defendant would have gone somewhere. We have tried, because clients have tried that, then come to me, I said, criminal action will not work. Please take the civil route. Seek for an appointment of an advocate commissioner with the police protection to go and seize the products if it is infringed, and not the other way. But as far as the criminal action is concerned, it spreads a fear factor amongst those counterfeiters. So the impact is instant. But civil, you'll have to wait for some time. But civil is more constant, much more permanent than a criminal action, what I feel. But as far as criminal action is concerned, when it comes to any other criminal action, mens rea is very essential. Intent. Here, intent is not essential at all. Next slide, please. There's only one judgment, 1972, which says both a registered brand owner and an unregistered brand owner can file under, take criminal proceedings under the law. Mark need not be registered at all. Next slide, please. This is just I've kept it here only to tell you that, if a suit is already filed and the defendant in his written statement challenges the questions of validity of the plaintiff's registered trademark, Supreme Court said that the trial court has to stay the proceedings of the suit, give the defendant 3 months time to approach the appropriate authority, at that point of time, Intellectual Property Appellate Board, now which has been abolished, now it has come back to the High Court, for the defendant to prefer an action to cancel the registration of the trademark and then continue with the proceedings. So it's either plaintiff or defendant. If the plaintiff claims infringement of his registered trademark, defendant can question it, or the defendant in his written statement says, my trademark is also registered, and the plaintiff in his replication says, sorry, your registration is not valid. Court will have to frame a preliminary issue that this is a tenable claim and send it, or give them an opportunity to approach the appropriate court for cancellation action. Without it, the suit will not proceed. So Section 124 assumes significance. And there is one last thing that I would like to tell you about as per trademarks concerned. The next slide. Groundless threat of legal proceedings. This is usually used, say for example, a party receives a legal notice, a legal threat, and they keep receiving threats despite responding to it. They don't stop. They keep receiving threats, either oral or printing or everything else. You go to court under this provision saying that it's a groundless threat. I'm entitled to use it, groundless threat. Without coming to court, they are just harassing me. The court can injunct the said party. But what it does is, it can help you pull that guy to come to court and file an action against you, so that you know that this guy is going to act, you can fight. Instead of waiting forever for the party to sue you, You file the suit. As soon as he files the infringement suit, this 142 action goes away. So 142 is only to draw a particular party to the court and file a suit against you instead of waiting for them to initiate action. And I've just take you over through some essential, interesting things. Courts have held that holy books like Ramayana and names of holy books can be protected. The Supreme Court in this case said names like Ramayana should not be registered as a trademark, as the same is common to trade. Everybody can use it. In fact, I used this particular judgment, one of the recent arguments that we had for the name Thiruvalluvar, which the orders are reserved. I'm still waiting. So when you choose a trademark, make sure that your client doesn't choose any of these famous holy books or deities' names. Deities' names in holy books are always problematic. Next one, please. Let us look at the principle of transborder reputation. What is the reputation? We talk about transborder reputation is covered in trademark law under the 1999 Act. Previously, it was only covered under the common law. It was not legislated. This was now under the new law. This has also been legislated. But very interesting case where Toyota was unable to restrain the defendant Prius Auto Industries from using the mark Prius, because it's a very important lesson for all the international brand owners. They were unable to show their reputation in India. Here, Prius said that I've been using Prius since 1997 worldwide. India, I came into being in 2010. But Prius Auto was using it for other accessories, or automobile accessories. The defendant said, I have registered them a trademark in 2001. Therefore, Toyota lost its case on the ground that they were unable to establish the reputation, the transporter reputation, prior to 2001. So it is very important that as a brand owner, even if you are not entering India, it is essential that you promote your brand. If you intend to spread far and wide, it is essential that the name, as the reputation, should be spread in India first, even before you enter into the picture. There's another one important question. Judgment. Next slide, please. These are some important principles of law that the court has held, the Supreme Court has held. Nandini Deluxe is Karnataka Cooperative Milk. Karnataka Cooperative Milk had its trademark Nandini Milk. Whoever is familiar with the milk there. Nandini Deluxe was the name of the restaurant. Nandini Milk, Karnataka Cooperative Milk sued Nandini Deluxe for its trademark. The court held Nandini is not an invented word. It's part of Indian mythology. And the manner in which they are traded, it is difficult to imagine that the consumer, the test that every court will apply in India as far as trademark is concerned is a man of average intelligence with imperfect recollection. Please remember that. Man of average intelligence with imperfect recollection. I am proud to say that this is a standard test which is applicable in India, and no other country has a standard test as we have. India alone, the Supreme Court has devised this standard test. You have to look at it from the point of view of an average customer with imperfect recollection. Right? Say, for example, even if it is APJ Abdul Kalam, he goes to a shop, he will not be thinking, is this the same brand as the other? He's just going to go pick up, look at it. If it is similar, he's going to pick it up. So you have to look at it from the point of view of an average man with imperfect recollection. That is a standard test. And that standard test was devised in India by our Supreme Court, and no other country, including US or UK, has this, any standard test. Next slide, please. Another interesting judgment of Supreme Court. Next one, please. The previous one. Book My Show. For those of you interested in this descriptive marks, Book My Show wanted to protect its Book My trademark against Book My Sports. The Delhi High Court said sorry. book my are two ordinary words, and you have not established that book my has assumed any reputation or any consumers identify book my only with book my show, and therefore held it against them. And last, let us discuss about whether trademarks can be or arbitrable. Next slide, please. Supreme Court recently, previous one. Supreme Court recently said, when it comes to arbitration, all rights in personam are arbitrable. Right in rem are not arbitrable. So, including intellectual property, if it deals with an agreement where the rights of intellectual property are more of a in terms of a right in personam and not about a registration of a trademark or right in any other right in rem, it is arbitrable. Plenty of cases, and recently Supreme Court in Vidya Dolia has finally concluded that no, right in personam is arbitrable, right in rem is not. And last but not least, I leave you with this beautiful observation or statement. Many injuries are the ways of infringement. Sometimes the falsehood is a little more subtle, the injury a little more indirect. This is by one of the famous judges of Delhi High Court, Awadh Bihari Harpi, in 1980. This is generally the principle of infringement, enforcement of a trademark, and I hope I've created some awareness about the law of trademarks, the fundamentals of trademark, and the enforcement of trademarks. And I hope you leave this place with a little more knowledge than what you had when you came here. Thank you so much.
Thank you, Rajesh. Do we have any questions here from our participants?
I'm appearing for the defendant. The plaintiff also filed the opposition petition before the trademark registry and is still pending before the registry. In my case, another person from UP also filed an opposition to use a word which was registered. The interesting thing in the US, the UP also filed a case against a plaintiff. On what basis the present plaintiff filed a case against me? Is there any other way they can file a case? Wait, I have to read it again.
Sir, can I explain?
Yes, please.
See, actually, I am appearing for the defendant here at Madras High Court.
Okay.
Whereas we are contesting for one particular word and trademark. Trademark is entirely different. Whereas this word is similar between both the parties.
Word is?
Word is similar between both the parties. That is plaintiff and me.
Word is similar. Word is
similar, and word is also registered as trademark.
Okay.
Word is also registered.
Okay.
See, the problem is the same word was already registered at UP by somebody else.
Okay.
But that UP person has already filed a case at Madras High Court, but that was disposed of. But we could not find what is the reason. But
Okay.
whereas the case is pending before the Bombay High Court, but using the word. In the absence of, in the pending litigation before the Bombay High Court, how this plaintiff can file a case against the defendant here?
See, probably the defendant would not have informed the court about the disposed case.
Yeah, of course, correct. Because while we scrutinize the opposition petition filed by both the parties, that other person was filed the case against the present plaintiff here. He shared the information that already I registered this word, which the case was pending before the Bombay High Court. You cannot use it.
See, whether the plaintiff has a right to sue you or not is one question. But
no, actually, the problem is plaintiff has filed a case against the court and injunction.
Against
us.
Correct. See, whether the plaintiff has a right to sue you is one question. That was the first question that they have to answer, saying that you can always question their right to sue you, saying that you yourself do not have a right. How can you question me?
Yeah, correct.
Okay, that is a defense that is available to you.
That is different.
That is a defense that is available to you. Plaintiff himself or itself does not have a right to sue. Does not have a right over the trademark that they are claiming. And therefore, they cannot sue me is one defense you can take.
Yeah,
but
correct.
Trademark is registered. Unless and until that registration is cancelled. succeeding with that defense will be a real dispute. So you will have to challenge that registration.
Yeah, correct. Actually, the plaintiff registered trademark in the year 1970, whereas our defendant registered the trademark slightly different name, but it is similar to the first word. First word is matching with the exact word. The second word is some other word.
The defense you can take is the rival marks are different.
Yes. Logo is entirely different.
Rival marks are different. It's only if it is only one part. Of course, I'll have to look at the both the marks to tell you a little detail about what other defense you can take. But generally, you can say both the rival trademarks are different. And you can question the plaintiff's right to sue you, saying that there is already a case which is filed and it has been disposed of.
Okay.
You can bring it to the court's knowledge. Apart from that, I need to look at the label to tell you what
No, actually, we already filed the return statement after the permanent injunction was granted by the court. That after that only we filed our return statement. We mentioned everything categorically. But however, judges asked us to file our proof affidavit, and for the cross-examination, everything it is posted for next month.
Okay. If necessary, you can also file an application under 124 asking for an opportunity to challenge the registration.
Who has to file application 134?
If in a written statement you have questioned the validity of the plaintiff's registration.
Yes, correct.
You can file an application on 124 seeking stay of the proceedings and ask for an opportunity to file a rectification against the plaintiff's registered trademark.
Oh, okay.
That option is available to you.
Even now, I can file application under 124 CPC.
There is no time there. The court might ask why it took you such long time. You have to explain though.
Oh, okay.
Okay.
Okay, sir. Right.
Oh.
Thank you. So, what is the problem that the trademark opposition is also pending? Then how this court can give a injunction on this present suit? Because trademark registry only granted the permission to use the word and logo.
Correct. See, if your trademark is also registered without either the registry or the High Court or the rectification application cancelling your registration, infringement cannot be granted. Section 28.2. Please read 28.2. Okay. Go through 28.3 if your trademark is also registered. As far as passing off is concerned, plaintiff has a right. You will have to establish by way of facts and cross-examination that there is no confusion.
No. Actually, my query is very simple. See, because they have filed a clear opposition petition before the registry. The case is pending before the registry. And their business is entirely different and my business is entirely different. They are comes under class 7. I am comes under class 17.
See, when it comes to litigation, what happens? Opposition is different from litigation. You still can maintain litigation here.
Okay.
Opposition pending is not an answer for litigation or a defense in a suit for infringement.
Okay. See, my class is different. No, their class is different. Still, they can.
The defense that is available to you on facts.
Okay.
They're all available to you on facts.
Okay, sir. Thank you, sir.
I guess, yeah. Thank you, Rajesh. Such an insightful session. As always, it was brilliant discussion starting from what is a trademark. We understood the categories, choosing a trademark, advantages, and of course, we had a detailed discussion on infringement as well. Now, the examples and cases which you shared with us were quite interesting. It was really very informative. Thank you so much.
Thank you. Thank you for having me.
Yeah. And for our subscribers, we are happy to announce that every month we'll have our featured courses along with the live sessions. Those who are already subscribed with us, this is the added feature to you all with your subscription. And for those who are interested in having a subscription with us, you will have access to our 80+ courses, which will include all the monthly live classes, interactions, and for the live sessions, we will be discussing the real-time, the latest topics, and would answer your questions in real time as we have done it today. So the featured courses for this month are insolvency and trademarks, and the class you have attended is on trademarks today. So I would just now quickly take you through our website and give you more information of all of the courses which are there on our portal. The screen is shared with you all. Just give me a moment and I'll just take you through the website. So when you go to ebclearning.com, so here there would be a tab where you can join for free. So you can register for free with us. Once you get yourself registered, you would have access to all our open-ed courses. Plus, you would be getting have access to 2 courses. You can audit those courses, which would include the assignments, the SSC online cases, plus all the materials that are there, videos, compulsory readings that I'll just show you another one. And so once you subscribe with us, so there are various monthly plans and plus the yearly plans for the subscription. And on your left-hand side panel, you can see the topics which are there on our course, on our portal. So we have topics on arbitration, mediation, AOR exams, business practice, business, careers in law, civil procedure and limitations, competition, consumer protection. We have got 3 courses, contract, we have got 9, corporate law, we have got 12 courses. Plus, we are also running a 2-year MA corporate law in collaboration with NALSAR, also an year diploma on corporate law with NALSAR. There is also one program that is an instructor-led program that we are running now with EBC Learning. Plus, there are all self-paced courses, 12 courses for corporate law, and then we have insolvency and bankruptcy, and then we have this intellectual property rights, in which we have 13 courses. So we start with introduction to IPR program, then we have software intellectual property rights, designs, geographical indications into international IP regime. We have introductions to form of IPR, copyrights, law of patents, semiconductors, plant variety, trade secrets, and one of our best courses on traditional knowledge and traditional cultural expressions with Rajesh himself. And for those who have attended today's class, so we have the separate course on trademarks here. So I'll just take you through our course on trademark here. So the length of the course here is 2 weeks. The effort is 2 to 4 hours per day, and you can purchase this course. Now, what's included in this course? This course will begin with the discussion of what trademarks are and the purpose of trademarks law. So you will be discussing the protection of trademarks, including the remedies available to those who have been infringed upon. And by the end, you will complete the course. Student will have a strong understanding of trademark law, and you will be getting a certificate as well. So I'll just take you a quick through with the course. What is it? So basically, this is a typical course with EDC. And on the left-hand side panel, you would see the content, what is all included. So we start with the meaning and definition of trademark, subject matter and product protection of trademark. We have types, then we have, so these are the videos which are given on the left-hand side panel. So for example, I'll just click on this one and you can have a look here, or maybe I'll start with an introduction.
Just like your name identifies you, a trademark identifies a business. Half-eaten apple is universally recognized as an Apple product. A swoosh shine means a Nike product. Trademark gives your company its identity. It's the trademark that builds the brand, which eventually builds your customer base. So we can say that a trademark is any sign that individualizes the goods of a given enterprise and distinguishes them from the goods of its competitors.
So this is the course done by Dr. Charu Mathur. She is also an editor with EBC Learning and also an AOR with Supreme Court of India. Within the course, you would understand the various topics relating to trademarks. So we have the criteria for registration, in which you would understand the grounds for refusal of trademark, including the full text of cases. The leading cases are also given here. So you have a detailed library for all the cases. And then there is infringement of trademarks. And then again, all the topics are given. So in case you are interested, just let us know. And thank you all. Thank you so much. Thanks, Rajesh, once again for the wonderful session. It's always great to have you on our portal and see you all again. Thank you so much. Thanks again.
Thank you.